Commissioner Terry Lipsey Scott is joining us on Zoom. No one else is joining us on Zoom. And I believe we're live, so I will call the February 26th meeting of the Pinellas County Charter Review Commission to order. My name is Brian Ongst. I have the privilege of being the chair of the commission, and I'll ask each of my colleagues to introduce themselves, starting on my right with the vice chair, Dr. Grove, sorry.
That's all right. Dr. Lindsay Grove, Public at Large Citizen Appointee, Vice Chair.
Wade Vos, General Counsel to the Charter Review Commission.
Dave Eggers, Pinellas County Commission Representative.
Ricky Butler, Commissioner Peters appointee.
Todd Jennings, Public at Large Citizen Appointee.
Rob Posovic, Commissioner Eggers appointee.
Mark Strickland, Commissioner Long appointee.
Anne Marie Brooks, Municipal Elected Official Appointee.
Mike Twitty, Constitutional Officers Appointee.
And I know we have Commissioner Terry Lipsey Scott joining us on Zoom, and I know we have Commissioner Steck here as well, who is taking a seat. So we'll get started with public comment. I do not see any members of the public here today. There he is, Mr. David Ballard Geddes. Come on up.
Hi, good evening. David Ballard Geddes, Jr. I live on Georgia Avenue in Palm Harbor. Regarding elections, our existing current
Sorry, Mr. Ballard Geddes. Can we make sure we start his clock? Thank you.
Regarding elections, our existing current Constitution sheds light to an election seen as an election of choice in Article 2, Section 1. As devolved, Article 3, Section 2 states, such election of choice shall rise as of fact from under this current Constitution, stating in Article 7 that this Constitution was elected to be under this Constitution as under the Confederacy as elected in pursuance thereof, declaring that mankind is more disposed to suffer. Based on the Declaration of Independence, this Constitution was elected to be light and transient, elected to be a candid world, elected to be pretentious, elected to eat us out of our subsistence, elected to complete perfidy and works of death, as declared constitutionally, electing to uniformly bankrupt and to capture the water supply in Article 1, Section 8, electing to actually invade in Article 1, Section 10, and the Fifth Amendment to take liberty, property, and life as elected in the 14th Amendment, deaf to the voice of justice as declared. In his farewell address, George Washington has twice elected to be one of auspice and critical posture, electing twice to lack authenticity, electing to propagate, to misrepresent motives, electing to indirectly undermine that which cannot be directly overthrown, electing to give us a useful lesson on our heads, to multi-generationally propagate, to calculate, to perpetrate the most enormous horrors, lacking principles, destructive, factious, ill-concerted, electing to be of greatest rankness, and truly one's worst enemy, electing to destroy the very engine which lifted it to its unjust domain. So I ask this board, what elections are we talking about when we're talking elections? Thank you.
Thank you, Mr. Ballard Geddes. Is there anyone else in the room physically that would like to make public comment on items that are not on the agenda? No. I see a Mr. Brett Schlatter on Zoom. Sir, if you would like to make a public comment, please go ahead and raise your hand in Zoom, and we will unmute you and allow you to have 3 minutes to comment. If not, no need to do that. Okay. Seeing none, we'll move on to the review and approval of the January 22nd, 2024 meeting minutes. Did everyone have an opportunity to review those minutes? And yes, Mr.
Chair,
Butler?
make a motion to approve the minutes?
Motion by Mr. Butler to
Second.
approve, and second by Mr. Twitty. All in favor, say aye. Any opposed? Okay, that passes unanimously. Next, item 5. We have the privilege of being joined by our Supervisor of Elections, Julie Marcus, who is here to help discuss some items of which she can provide significant expertise and experience. And I know we're just kind of starting out here in distilling some of the items that we're focusing on as it relates to petitions for citizen initiatives, percentages, charter referenda questions being on the general election ballot as opposed to being able to be on special elections, things like that. But a lot of this stuff really would have an impact on the Supervisor of Elections office, regardless of who the Supervisor of Elections is. We are privileged to have an excellent Supervisor of Elections with many years of experience running this office and serving in this office through numerous elections. And it's our privilege to welcome her. So, Supervisor Marcus, the floor is yours. Thank you for joining us.
Thank you for having me. I do understand that I'm here to talk about the petition process, initiative petition process for the county charter. As you know, I have a role as the Supervisor of Elections. I also have a role as a canvassing board member, statutorily. So as a canvassing board member, I wouldn't be able to make any kind of up or down on things that may end up on a ballot, because then that would preclude me from serving in the capacity of a canvassing board member. So that, I just want to make that abundantly clear. So I'm not here to give pros and cons to something that could end up on the ballot itself. But I am a process person, and I do know that you all have, I think, I don't want to speak for you, but if you could please, I need some sort of start date, because that's kind of how we work in our office. So there's kind of this, we know that there's an election coming, and then we work backward. So if I could at least have the CRC give me some sort of proposed start date, and then I can work back from there, if that makes any sense. Please, Mr. Chair.
Yes. Do you have other things that you'd like to share with us before we start asking questions, or do you want us to discuss that amongst ourselves and ask you about that in particular?
Yeah, I think if you don't mind, please.
Yeah, absolutely. And so one of the things that you'll find in your packet, if you don't have the full charter in front of you, I believe it is in section 7D, no, I'm sorry, C, regarding the Florida Election Code. And it's is in terms of the section of the charter, it's section 6.01 or 02 sub B, and it talks about how how a citizen would bring a petition to the ballot, and that's the process, and it's only a paragraph long, and it starts out by saying the sponsor of a petition amendment shall, prior to obtaining any signatures, submit the text of the proposed amendment to the Supervisor of Elections with the form on which the signatures will be affixed, and shall obtain the approval of the Supervisor of Elections of such form, which to me sounds a little odd. So basically, we're asking, probably in some cases would be a layperson, not a political committee, not necessarily an expert, not a lawyer, to just make something up and go and hand it to the Supervisor of Elections for the Supervisor of Elections to bless, which then puts the Supervisor of Elections in a very unusual situation where it's like, is the Supervisor of Elections supposed to give this person advice? Probably not. Are they supposed to be negotiating over it? Probably not. That seems very odd to me in thinking about it, and really looking at what it says right now in the charter. And then it goes on to say, the style and requirements of such form shall be specified by ordinance. Okay, so that means the county commission creates the style and substance of the specified form. But then it says the beginning date of any petition drive shall commence upon the date of approval by the Supervisor of Elections of the form on which signatures will be affixed, and said drive shall terminate 240 days after that date. That doesn't take into account when the election is. It doesn't take into account what the deadline is for the supervisor to certify candidates and certify ballot initiatives from cities and the county and other processes, and to print the ballot. So in reading this, it doesn't give the petitioner, the person that's supporting the initiative, any guidance on when they're supposed to start. It just basically says, hey, show up to the supervisor's office, hand in some kind of form, and then you have 240 days, but it doesn't tell them the practicalities of actually printing the ballots, certifying the ballots, and the provisions of state law that the supervisor has to comply with. So I think this is a ripe area for discussion. And prior to the meeting, I asked Mr. Vose to kind of give some thought to what other counties do in this regard. But I think that is that a good introduction kind of to the topic, Supervisor Marcus?
Perfect. Thank you, Mr. Chair.
Okay. Yes, Commissioner Eggers, please.
Yeah, and I think date specific would help not only the supervisor of election, but it would also help the group that's bringing forth the petition. So I think the state calls for a February 1 date, but I mean, let's just, we can back up from our election date to see how far back we want to go, like when it has to be submitted, and if that's April 1, February 1, or whatever. But it does also help the petitioner. Then they can back up from that date to figure out when they want to take advantage of that full 240 days. And I think it just works to have that set date. So whether it's January or February 1, March 1, or April 1. And I was backing up from the election, and April 1's probably we wouldn't want to do it any later than that, but it's getting so close to the state, you almost want to maybe consider sinking in with whatever the state does on that. But
sure,
we'll see.
Yeah, no, I think it's a really good area, and I'm so happy that Supervisor Marcus, that you brought this to our attention. And County Attorney Jewel White is also here with us, and we have the pleasure of seeing you again. Thank you again for coming back. And if you want to shed some light on the process and what we might address here.
One of the things I just wanted to kind of mention and follow up to Commissioner Eggers' comments. I have been one of the people in the past that when folks are trying to get together an initiative for, pick your topic, whatever has been, a topic in Pinellas County in the past. And Julie's predecessor in office always asked me, hey, could you help the citizens out? Because, of course, they contact her office, and they're not necessarily intimately involved in it. And as you keyed on, in my opinion, shouldn't be approving the language, of the question. That's altogether different. We've always taken the perspective that we're looking at the form. So 15 words for the title, 75 for the question, and then otherwise all the information on the petition that her office needs to verify. But again, to follow up with Commissioner Eggers, I would communicate with people that we're trying to get these initiative processes together. And, I can't give them legal advice, but I would give them, as much information as I could from the charter. You have to get, 10%, then 8% of registered voters from the last election. Here's that number of registered voters. You have X number of days to do it. But I can tell you my experience every single time was frustration on their part that they didn't have a more solid process to follow. So I agree, I really do think it would help the citizens if there was a little bit more of a roadmap, at least time-wise.
And County Attorney, could you also walk us through what is the process that the County Commission has to go through? Because even if it's initiated by a citizen, the County Commission still has to pass a resolution, is that right?
That is correct. In fact, the County Commission has to pass a resolution to put any question you all advance on the ballot. So it's a resolution. It's something that could be taken up at any regularly scheduled meeting of the commission. Usually we're putting agendas together, 2 to 3 to 4 weeks in advance of those meetings so that they can get out and be published and so that the citizens can see the agendas, a meaningful time in advance of those meetings. So, I would say probably for that process, because the County Commission, again, does have to pass that resolution, and then there's advertising requirements that you have to be able to meet as well. And if you all recall, that's something that I had mentioned that I hoped we could get into line, because the state statute requires 4 advertisements, the county charter requires 2, but because of the timing that the charter employs, we end up having to run 5. So that adds another 5 weeks to the process. You're going to have 4 weeks anyway because of the state advertising, but I'd say between that advertisement, which we do set forth in the resolution. These are the 4 dates, previously 5. Hopefully you all will entertain a change to 4. But these are the dates that this will be advertised. So currently, those advertisements are taking us about 6 weeks. So I'd say you need to probably build another 6 weeks in for county commission action. So that's about 90 days you're looking at, subsequent to Julie and her team finishing up with, certifying the signatures.
And Supervisor Marcus, I know, and I'm not an expert on this, but in state petitions, there's a very, very regimented process. The Secretary of State has a website for petitions, and each petition is listed. They have different deadlines for when they hit the criteria for Supreme Court review, all of those things, when they make it on the ballot. It doesn't matter what percentage, 8% is the current percentage. Do you have any idea how long? I mean, I'm trying to think about the process and the impact on your office. And so if I show up and I've got, 25,000 signatures and I give them to you all on the same day, I'm guessing that would be an incredible burden on the office. So do you have any thoughts on the process for certifying the signatures? And because I feel like we should probably think about addressing that as well, or how that would work.
Okay, so I think, let's just, taking into what Jewel said. So let's pick an election date, okay? So we have an election that you all say this is when we're going to have initiative petition ballot language on that date. Can you, a general election, okay? So then our general election ballot language deadline is a week before, the Tuesday before the August primary. So all of our municipalities, the school board, county, everybody gets their ballot language into us on that Tuesday so that we can start preparing ballots so that when the primary is done, we're adding to that, and then we can get what we need to get done so that we can get ballots mailed out to overseas voters timely. So now we have that date, Tuesday before the August primary. So now take everything Jewel just said, back it up. How much time do you all need for that? Then I'm just going to give you what the state has, because that's what I have to really work with. That's very detail oriented. The state has many areas in the law in regard to proposed constitutional amendments. It speaks like literally one sentence on referenda, and then it goes into constitutional amendments. It has rules, all these things that have to do with this process. So how the state does it is they have a February 1st certification deadline. So if you want to have your petition accounted for and you want it to be on that ballot, it needs to be turned in by February 1st. The state also says you have, as a committee, now maybe I should start at the beginning, okay? So first, the state says if you want to do this as a initiative, you need to basically file certain paperwork to become a political committee. Now, the state's like, okay, we know you're going to be doing this. And the state has a form, and then they attach a serial number to it, the ballot language that the group came up with. The Secretary of State looks at it and they say, okay, yep, 75 words, yep, it has 15 in the subtitle, that check, but it's not looking at financial impact, it's not looking at the merits of the language, and it's not looking at the translation to Spanish, because that is something that also Pinellas County would need to think of. It's only looking at those very basic 15, 75 words, and yes, no. Check. That's what the Secretary is responsible for initially. And the form already exists with the things that the supervisor needs to verify a petition signature. We know there's lots of John Smiths, so I would need to make sure that we have that, an address. Are we allowing people to make address changes like it does on that form that the state uses? You need a date of birth. You need to make sure that the voter signs it. They add a serial number because there's multiple groups trying to get on initiative on constitutional amendments on the ballot, so they serial number them, so on and so forth. So there's all of these processes that go into just the form itself. So those are decision points that the CRC would need to consider. So now you have the forms approved, and because now you have a political committee. The political committee has 30 days to get the petitions in. They must submit them under the law. They can't just collect them and then stash them someplace forever. They must be submitted. And then we have 60 days to verify them up until December 1st through the February 1st deadline. Then it becomes 30 days. If you come in on January 31st with 10,000 petitions, and there's other groups, it's first come, first serve. So we're going as they come in. And so if you are the third group that came in and we have 30,000 more to look at before we get to year 10, we're going to do the best that we can. And this was an issue that we had seen in the past. Folks were like, well, what's the deadline to turn them in? And we didn't have an answer for them because there was no deadline. There was nothing. There was no process. And we're trying, of course, we want to make, this is the most purest form of democracy. It literally circumvents the concept of a republic. It's direct stuff to the ballot. So we want to make this as seamless and as transparent as possible, and not having deadlines is a really big deal. So we couldn't answer that question. We were like, we don't know when you should bring them in because we don't even know how long it will take the BCC to get through what they need to before our ballot language deadline. So that's a big issue. So if they brought it in the day before the deadline for us to certify to the state, we'll do the best that we can. But to just codify like, we can get through 10,000 petitions in this many hours on this many days. It's hard for me to say that because we're like right now, we're in the middle of a presidential preference primary. Well, what if we're not? And we're in the middle of municipals, maybe it's different. What if you've got 7 other initiative petition groups that are trying to do constitutional amendments, trying to get stuff done while this group's going? So I think to pigeon me into like it takes this long to do this many petitions. And another thing that's really important, the better your group is at collecting petitions and making sure that the form is completed and that they're actually registered voters and so on and so forth, the faster the verification process is. If you're not good at doing that, it actually takes longer. Because then you have to go through all of these different ways to try to find the person that the person may have signed, trying to get through address, trying to do the birthdays, trying to see if they're in the right districts, trying to see all of this. So it actually takes longer if you don't do the petition correctly than it is if it's done correctly. So those are considerations to take. Those are things to consider when you're, so that's why I say don't pigeonhole how long does it take. Just give us a block of time and say it must be done within this. And the state's already doing 60 days, and then during that December 1st to February 1st, we have 30 days. But even on January 31st, let's say you drop off 10 and I can get to 2,000, right, the next day. We still have to keep verifying up to 30 days the other 8,000. And submit that to the state. So we have to look at all of them and keep going. And those are decision points you all need to make because the state has carryovers versus other deadlines that the county has in regard to how valid the petitions are. But I think you need to really consider, like, who is coordinating this effort? Who is our point of contact? Do you want political committees? Do you want just a coordinator? I don't know that, but I know that it made it very difficult when folks were trying to get questions answered from us. We would have 3 or 4 different people on the same topic contacting us, and we didn't know who the point of contact was. Whereas the state requires like a coordinator who is required to submit them to us, who we're supposed to communicate back to the state. We submit stuff to the state publishes it. It's all very fluid and transparent. That's off the top of my head.
Okay, very good.
For further discussion.
Yeah. Attorney Vose, did you have a comment?
I did, Chairman. Thank you. As the supervisor was speaking about all these different issues, I was actually having flashbacks to 2016 in another part of the state. I had a little bit of a conversation with the chairman prior to the meeting. In Orange County in 2016, Orange County's initiative petition process looked very similar to the way Pinellas's is now. The language that's in Pinellas's is kind of stock charter initiative petition language without much meat on the bones or framework, as your supervisor was mentioning. There was a big reform effort in 2016 in Orange to add a lot of meat to the bones. Quite frankly, right now, there was so much added to it that in Orange County right now, they're looking to rip out about half of it because they think they went too far. Nevertheless, a number of the issues that your supervisor just mentioned were addressed in those revisions. One was relating to the idea, rather than you have a window of time and folks can collect petitions and then wait till the day before the last day and come in with big old stacks and drop it on the table, that went out the window because that was not seen as workable ultimately by anybody with any interest involved in it. It moved in that instance to a process where after, I think it was within 5 days after the end of every calendar month, all of the petitions collected in that prior month had to be turned in. And then in that instance, the supervisor's office had 30 days to verify those signatures from the time those were brought in. And it kind of went in that cyclical way. In addition to the matter of, do we need to have a political committee or anything like this? This is a very common confusion that folks would have there. When it was looked at over there in Orange, and actually when I looked at it, I came to the conclusion that as a technical matter, any two people organizing together to put something on the ballot and they're going to spend over $500, technically that's a political committee and they would be required to register. And as a result, to make it real simple and easy for folks so you didn't have to explain all of election law to them, it was added into the charter stating that you had to organize as a political committee pursuant to Florida law. But just offering that I've reviewed pretty much every county charter in the state concerning initiative petitions, and adding a lot of this meat on the bones has been done at least once. So we have something to draw from if anybody's interested in adding any of these pieces and parts.
Commissioner Eggers?
Okay, I'm trying to, in my small scope here, trying to understand the process. What you just went through, Julie, is from a standpoint of prior to the primary, got us back to like the middle of August. You said it had to be before the primary that all of the languages had to be in to you, or had to be done by that time. I'm sorry, by all the cities and all that had any languages that had to go on the ballot for November. Did I hear that?
Yes?
Yeah.
Yeah, so it's the Tuesday before the primary. So you can always just land on whatever the primary is. It would be the Tuesday before that.
And if we were talking 6 weeks for the county commission, and even if it's 90 days to approve signatures, I mean, I'm just trying to give like lots of time for a charter review process, which is not the state's process, it's our process. Mm-hmm. So and you start backing that up, and you at least get to April 1st without much effort. And we can go through that and lay it all out on a screen and all that stuff so that we can all follow it. But I mean, it's not that much further to go back. Does it help you if we put it the same time as the state? Like February 1, we have to have, all the signatures have to be to you by that date. Does that help you? It gives you more time? I mean, I'm just trying to get into your process within your department.
Yeah, and I appreciate, Mr. This is a delicate balance between access to the process and then the process being able to flush itself out. The only that gives me some reservation about an April 1st is during an election year when we have a presidential preference primary, which would be like this year, for example, that March month that these folks could bring in 30,000 petitions, and we're running what we, because now we're running a federal election in conjunction with trying to verify petitions for the county per the county charter. So that would be the only, I think that's probably why the state has this February 1st, because it's before any election that takes place. that they're required by law to conduct. But I am not going to, I don't feel comfortable landing on a date that you all should pick on that, because I understand that that's a very difficult decision.
Yeah, I understand. What I'm trying to get at is exactly that, because there is a presidential primary in next week.
In like 3, yeah. Yes, coming right up.
So does it, I would think to get them in before that started, at least, I'm presuming you can, I mean, it'll be conflicting with some of the ballots that you're getting in for that March presidential primary, right? If we say it's February 1st, I mean, I'm not trying to get into the weeds too much here, but I really think understanding your time frame, and then that date becomes so important for those who are trying to file a petition or a referendum. So I'm beginning to think that, I was thinking April 1st was plenty of time, but I don't think it's plenty of time. It almost needs to be the same date that the state's doing it, just to be in the same kind of rhythm that you all have. But I don't know.
Commissioner Steck?
Yeah, I have 2 thoughts in regard to this. And first of all, based on your initial question, I'm guessing based on some of the wording in these documents that the idea is to have an election regarding a suggestion from the public to occur at the same time as an already planned election, so there's not an additional waste of funds in regard to setting up another election specifically. So if that's the case, I'm assuming we would pick this November 5th as an example to start this, and then work backwards from that. Right. The second thought I had was, based on all your comments, it sounds like that somebody somewhere ought to put together a kind of an overall guideline procedure to, for the citizens who have an interest in doing something like this, to understand what it is they're getting themselves into, and the kinds of steps. For example, you have to collect 30,000 signatures. Can you turn them in as you start collecting them, or do they all have to be turned in at once? And those kinds of questions could just be in a general document that would be made available to the public in maybe 10 or 15 pages. So we don't get into the weeds, as you were saying, over in Orlando, but just give folks a general guideline so they understand this is not going to be a weekend activity.
Other comments or questions for Supervisor Marcus, or discussion generally? We do have some draft language later that does not address the date or the start date, but addresses some other things that we're going to talk about later, about percentage and November versus special elections and all that stuff. Any other questions, comments, concerns?
If I may,
of course.
Just to address one of the questions that you had, obviously picking when you want to have them is good, because then there's structure. I think it's really important for transparency and for understanding, because this is a very complicated, complex concept, initiative petitions. I know it seems simple, but it's not. There's many different layers, lots of things that the CRC needs to consider. Something that y'all might want to look at, I sent it to your attorney for consideration, was the state has a initiative petition handbook, and it has like flow charts and graphs and all of this information in there. And I think that would be maybe a place to just things to think about. Because like I said, there's all of these considerations. Do you want to have because it starts like you have to form a political committee, and then there's this has to be approved, and this is how this works, and then it gets a serial number, and then you can start doing this, and then you have campaign finance reports due. It like walks through this whole entire process, because if you form a political committee, there's requirements under the statute for those folks, and forms that have to be filled out, and then campaign finance reports that have to be, and that has nothing to do with going out and collecting petitions. So I think that could be something that could be helpful. I think from our perspective, again, is we have a ballot language deadline. Work back from that, give the people some sort of structure so that everybody knows what is expected, what's expected of their government, so that we can have good, healthy elections, you know what I mean, that make sense.
Commissioner Steck?
Just as a follow-up, my thought was, we have an election cycle. If someone starts a petition activity and it doesn't happen to be completed for that election cycle, well, then things just sit, and then they were added for the next election cycle. And they, you know, I don't know if that's something like that could be done. So they don't have to start at a given time. They will just, when a thought occurs to them, they go ahead and do some discussion, decide what they want to say, move it along, and if it's the time frames that are required, at this point they're talking about 240 days and so forth. If those dates don't end up fitting into this particular election cycle, well, it's going to have to roll over to the next available election.
That's a decision point on your all's part. Again, I'm about a process, and really, let's talk, just to end on the form. Again, our perspective is the Secretary of State's responsibility is extraordinarily limited. Is your subtitle 15 words? Is your text 75 words? Does it say yes, no? Meaning that small little, literally a sentence in the statute. And then beyond that, the merits, the fiscal impact, these are all things that, who's approving that? I mean, as a supervisor, I would want to be involved with at least the county attorney's office to say, can you please make sure that this, and this is on the petition so we can actually verify them? But who's making all of the decisions about at what point is the ballot language not going to end up in litigation because it didn't even meet basic single topic concepts? You know what I'm saying? Does that make sense?
Yes.
Okay.
It certainly makes sense to me. Any other questions or comments, concerns? County Attorney, did you want to make another?
One thing I'll just kind of bring to everyone's attention that we haven't really talked about. The charter does currently say that once it goes to the county, that the county is going to put it on the next well, it says next election. It does provide for a special election currently. I know that it looks like you all are going to talk about that. But it says the county commission will put it on the next general election ballot occurring in excess of 90 days from the time they take action. So that kind of gets at that 90-day kind of period I was talking to you about. But another thing that this says, and I don't know that you all would want to go this way, if you don't want to get bogged down in details, you do already have in here, and this gets to the form of the petition. It specifically says in the charter, it talks about the sponsor of a petition, obtain, submit the text to the supervisor with the form in which the signature shall be affixed and obtain the approval of the supervisor. It then states, the style and requirements of such form shall be specified by ordinance. We do have an ordinance here in the county that goes over that, which does state from the county's perspective that the supervisor is approving the petition as to form, and it very specifically says not legal sufficiency, which I think is fair. I don't think that the county or the supervisor or anybody should be getting involved in what those ballot questions read like, because then after all, whoever's mad about the results is going to say that we tried to steer it in that direction. Just speaking from experience from a lot of years in county government. I don't think that and they don't do that at the state, we wouldn't want that, but just, there is a provision already in the charter to work out some of the details by county ordinance. You all could direct that happens, it's really up to you, but that is something that's been done, and if anybody wants to look at it, it's section 2-2 in the Pinellas County Code that talks about that petition form.
And maybe Attorney Vose, it sounds like we're going to add this to your list of things to maybe bring back to us soon for conversation. Anybody want to give your thoughts to Attorney Vose now on what we're looking at? I mean, I would be very interested to see what Orange County did and then also to see what they're undoing. The political committee thing, it's such a, it's statutory. Mm-hmm. And it's just like you said, and I've seen so many citizen groups, particularly groups that are opposing referenda, that do not follow that. And the threshold of having 2 or more people spending $500 on something is very low. So if you're going to Staples or Office Depot and you're making homemade signs, you're still probably getting close to that $500. It does not take much to get there. And I don't think most people make a big deal out of that, particularly when neighborhood folks are opposing something. Certainly it's not something that I've ever seen somebody, make an issue out of or report them or whatever. But if you are collecting petitions, particularly if you look at the petitions that actually make it to the constitutional amendment on the state ballot, I mean, those are highly organized, most cases, highly funded. Not to say that you need to be highly funded, but you still have to comply with the law. And the law is statutory and also ordinance by the county. And so just because we don't have something in our charter that says you need to form a political committee, that doesn't mean you don't have to form a political committee. And it certainly would be helpful for those folks to understand that. Supervisor, yes, please.
Okay, so just for the record, it's 106.03, and it's subsection 1A. Each political committee that receives contributions or makes expenditures during a calendar year in the aggregate amount exceeding $500 or that seeks the signatures of registered electors in support of an initiative shall file a statement, and this is what I was talking about. Just to be clear, the initiative does not mean public measure. So the Department of State, that initiative concept, because I know that rings because we talk about initiative petition process, but that is, the state does not take that word and bring it down to the state level. To the county level. Public measure brings it down to the county and doesn't speak to that. So the initiative section of that statute is speaking to constitutional amendments. And then it just says a political committee, and it did used to say 2 or more people, but now it just has that threshold of dollar amount for clarification.
Okay, thank you. Mr. Vos, do you want to get any more direction from us before you come back with some thoughts on this for us to consider, or?
I would welcome any further direction. Would you mind if I ask the supervisor one question very quickly?
Please.
I was reminded in looking through all of this when you mentioned your ballot deadline for the November ballot, something that's always stuck in the back of my head in the Pinellas County Charter. As a technical matter in the charter, the work of the CRC, their final report's not technically due until July 31st, which is way closer than it should be to meet that deadline.
Your
the CRC's report that would then have to go to the Board of County Commissioners for them to pass a resolution prior to your deadline very shortly thereafter. I can tell you 8 years ago, we said, yeah, that's nice. It says July 31st. You're getting done way before that. It never rose to a sufficient level where they thought, we need to change it in the charter or anything like that. But I did want to ask, since we're making other changes here to these points,
because
I think it makes sense that that's a little
state statute used to be 8 weeks between the primary and the general, then it was 9 weeks, and now then it was 10, now it's 11 weeks in between, and we're just asking for that extra week so that we could start building to stay on track. So anyhow, yeah.
That language was all written way before the Help America Vote Act and all this stuff, I think, so.
Okay. But yeah, that would be.
Last BCC meeting in July is July 30th this year. When we know that things are coming forward, we get placeholders put. For this group, it's significantly easier for us to predict what's going to move forward than it is with the citizens initiative petitions, just because of all the many topics that we've discussed today. But when we know that there's questions coming from a group like this, we'll have everything ready to go and a placeholder put there. But just for your information, we actually have 2 meetings in July this year, which doesn't always happen. There's one the 16th and one the 30th of July. But then we do start to get precariously close to that deadline, which is it August 27th?
And my preliminary advice thus far is they don't have to wait till July 31st. So we're probably not going to get anywhere near there if we can.
Yeah.
In any event.
Yeah, we would be getting very close to, very, very close to their deadline if we didn't get it probably by that last meeting and that second meeting in July.
Commissioner Eggers, did you still have a comment?
Yeah, so other than sensing a lot of frustration, you feel it. Maybe you're not. Okay, fine, I misread. To me, coming out and I think saying, February 1st and staying in line with the state simplifies things. It gives plenty of time. I shouldn't say plenty, that's the wrong word since I haven't got through the process. But it gives a lot more time than we have now. And it gives certainty. And I think if you back that up from November through August and then the 6 weeks and all of the stuff that goes into it, you're at least April 1. If you have a presidential election primary in March, then you're back to the state date. And if we're giving them 8 months, just thinking out loud, you're talking, what, is that June 1st? If you gave them the 8 months to secure the petitions to turn in?
June 6th, I calculated it, but
Okay,
you
so.
could just set a beginning date as June
So
1st.
again, for clarity for our residents, that they have to have, not the substance, but the mechanics approved no later than June 1 to give them the full 8 months to acquire the signatures that we're giving them.
I don't know if it's no later than June 1 to start. I think it's that the 240 days begins on June 1. And so if you want to start after June 1, it's at your own risk.
Okay, well.
Does that make sense?
That's fine, yeah. But I
Okay.
mean, again, if we're trying to do two things, one, make sure that there's a time, at least a time certain for the 240 days minimum that we're allowing, but they can go, I mean, or maximum, they can go less. But again, we're trying to do two things. One is set up something to govern us, but also to help inform the public. To your point, there's a whole bunch of things we can help inform the public, but,
That makes a lot of sense.
I mean,
Commissioner Steck, did you have another comment?
Yeah. Mr. Vos, if you'll help me, my dust the cobwebs off. At the last commission, wasn't there some kind of requirement based on the fact that whatever was proposed by the commission didn't have to go through a couple steps that a normal public citizens incentive would be required to go through? Or am I not remembering that?
The difference between the Charter Review Committee and a citizen petition?
Yeah. I thought there was some kind of a.
We put it right on the ballot, right? We don't have to collect signatures.
We don't have to collect signatures. It does, under the current structure in the charter, it does still have to be put on the ballot by resolution of the Board of County Commissioners, but that's a ministerial act. They're required to do that. You just have to make sure there's sufficient time in there for all that to happen. I'll tell you, just as an overarching thing, when you see language like this that has this 180 days, 240 days, whatever it is, the reason why you tend to find language that has such generic language like that is it's often that's paired with it saying it will go on the next countywide ballot more than X days since, after certification or what have you. So it can roll with a primary or a general or a presidential preference primary or what have you. In this instance here, it's almost completely locked down. It's on generals unless the board puts it on a special. As you all know, one of the things before you all to discuss is the possibility of saying, nope, just in the general. That boils it down to that's the only election it can go on, which makes it a lot easier to drill down to say we're going to set a firm date as opposed to windows of time that are always rolling.
Okay. This will be something we talk about going forward. Anything else at the moment? Supervisor, any closing thoughts? Or
Thank you.
You were very helpful. I appreciate it. Thank you so much.
Thank you so much for having me.
And just for the record, everybody, we have invited all of the constitutional officers, not just the supervisor, and we've invited all the county commissioners, and they've given feedback through their representatives and through the county administrator's office. So I appreciate your participation and education and helping us understand the process and some areas that we might want to look at. So appreciate it.
Our pleasure. And if any follow-up comes up and you want to call our office, please, or Jewel, we're more than happy to help. Thank you.
Thank you so much. Take care. Thank you. Okay, moving on to new business, item 6. We'll start with 6A, review and discussion, overview of constitutional concepts relating to transfer of powers and consolidation of services and discussion of relevant Pinellas County charter provisions. Mr. Vose.
Thank you, Chairman. We'll start off with a light topic. By the way, sorry for this memo and the next one, both get into a little bit of heady Florida constitutional concepts here, but I want to lay it out in writing, and I'll give you the 10,000-foot version, and then we can discuss, and anybody can ask any questions. One of the topics that was brought up in your discussions was the question of what you might call transfer of powers or consolidation of services, particularly about the idea of using a county charter amendment to unilaterally require consolidation or transfer of services from one jurisdiction to another within the county. The long and the short of it, as the memo lays out, is that in the Florida Constitution, we have a tension between two different provisions. One that requires, that relates to transfer of powers, and generally requires that when you have a transfer of powers from one local government jurisdiction, a city, county, or special district, to another, you need generally two things. You need joint resolution from both governing bodies, and you need a dual referendum. It needs to be passed both by the electorate of both jurisdictions, all right? At the same time, we have another provision, a competing provision, that says within charter counties that a county charter can provide which prevails in the event of a conflict between municipal ordinances and county ordinances. For a number of years since the '68 Constitution was passed, charter counties pulled out that second tool and tried to use it against the first. And so there were a number of instances where charter amendments were proposed or went through seeking to use that power to take over various services, primarily from municipalities. Basically, through a series of Florida Supreme Court opinions, the Florida Supreme Court ultimately arrived at a division. And that division is the transfer of powers requirements with dual referenda applies to the transfer of services. But when it comes to the transfer of regulatory power, that's not what the transfer of powers is talking about. Regulatory power can be preempted or transferred from municipalities to the county government through a county charter. So that's the distinction you have. There are a number of instances where that's been put into implementation. For example, in Seminole County, when Seminole County preempted a very huge chunk of regulation, preempted all land use regulation east of a certain line in Seminole County. That's called the rural boundary in Seminole County. That went up to the 5th DCA, and that was upheld on the basis of the constitutional provisions I just described. There has been some further development by the Attorney General's office. They took a look at a more nuanced issue. The question was asked initially, and this is kind of a textbook example when people ask, hey, can we use the county charter to consolidate all the fire services of, say, all the municipalities in our county? Answer is, no, you can't. Fire service is a service. However, the Attorney General came down on the side of saying, well, you can't consolidate those services. However, you can implement countywide regulations that regulate those services. So you can impose uniform standards and so on. So that's the general rule among charter counties in Florida. As is laid out in the memo, however, Pinellas County is a little bit more of an articulated situation. There is a provision in the Pinellas County Charter 6.04 that has, as some of you may know, has been the subject of litigation in the past in Pinellas County, which I understand is all calmed down and copacetic now, but was quite the thing way back when. Ultimately, what that provision requires is that any charter amendment affecting any change in function, service, power, or regulatory authority, note the difference there, of a county, municipality, or special district allows it to be transferred or performed by another county, municipality, or special district only after approval by dual referendum, okay? So the effectively, of 6.04 is not just the transfer of services, but also the transfer of regulatory authority can only occur with the approval at a dual referendum of the jurisdictions that are being transferred to and transferred from, okay? Now, you may wonder, well, the charter has a number of instances where the county has, preemptive municipal authority and so on. A couple different things. One, a lot of that was all in the original charter that came from 1980, well before 6.04, the time 6.04 was put in there, or it was added by subsequent special act before 6.04 went in. So that's the current situation that you have in Pinellas County. I know reading back through the old historical records, it's been a perennial topic of interesting discussion. Should we consolidate, for example, all the fire services or some of them in Pinellas County? Basically, looking at the county charter alone as a tool, that tool does not provide you the option to do that. But I'm glad to answer any questions.
Okay, questions on consolidation of services topic? No? Okay, moving on to 6B, review and discussion general overview of case law relating to county charter amendments affecting budget and millage. Mr. Bose.
Thank you, Chairman. And again, I despise being an attorney who says, no, you can't do that. But I got somewhat two instances here. This second memo addresses relevant case law relating to instances with charter counties looking at charter amendments that affect or limit or control the budget or millage of that charter county. Basically, what I've laid out in the memo is a number of instances where in Miami-Dade County, then Dade County, Charlotte County, Hillsborough County, and Brevard, various different instances of this were attempted, a lot of them relating to controlling or limiting the millage. In Miami-Dade County, folks did an initiative petition to set the millage instead of having the Board of County Commissioners set it. Nice try. The Florida Supreme Court said you can't do that. In the instance of Charlotte County, they tried to put what was a common and very popular idea around the state. They tried to put a cap on the ad valorem millage rate, or a cap on the increase in total revenue from the millage rate. That instance, the second DCA looked at all of that, looked at that case out of Miami-Dade, and said, no, the Florida Supreme Court said that chapters 129 and 200, 129 is the county budgeting statute, 200 is the general statute for a general chapter for setting millage and adopting budgets, that those were the exclusive statutory scheme for establishing budget and resulting millage, and as a result, a county charter could not impose limitations on any of that within their charter. Same thing happened again in Brevard County. In Brevard, they tried basically the exact same or very similar one to Charlotte County. It was also shot down by the 5th DCA, but they did something different in that instance. Brevard County, actually it wasn't Brevard County, but folks who were in support of it in Brevard County went to their state legislators. State legislature passed a special act. That special act was subject to a referendum because under the Florida Constitution, a charter county cannot be subjected to the requirements of a special act without it being approved by referendum. So it's approved a referendum. That special act authorized the Brevard County Charter to put in a millage cap. So it was a two-step process. Special act was passed and then approved by referendum, and then they put on a separate charter amendment and it passed. And so now Brevard is the only county in the state that has that type of provision in action enabled by a special act. I did mention in the memo that there is a provision in the Jacksonville charter and the Duval County charter that seems to read very similar to the Charlotte County one. I have not had the opportunity to contact them to see if it's in effect or anything like this. It popped up kind of around the same time when these other ones got popular, and I don't know if nobody ever challenged it there, and it's just the way things are in Duval County. But with regard to what was attempted there, I can tell you the established case law in Florida says you can't do that. Now, to the particular question of, all of these technically were directly relating to millages. All right, well, hey, instead of regulating the millage, can't we cap the budget? Right, we'll attack it from another way. Well, at least the Florida Attorney General's office has come to the conclusion that all of these cases stand for the proposition that you can't, it's not just you can't cap the millage, you also can't cap or restrict the budget. that the budget and millage process has to be subject to the annual process that things go through for the Board of County Commissioners to set their millage and adopt their budget, and additional restrictions placed on that in a county charter would be contrary to general law. Now, there are a number of instances where I categorically disagree with the Attorney General's office, and I don't put much stock in what they say. In this instance here, I think the reasoning is relatively sound from the Attorney General's office. In any event, this I would offer to the CRC is the current state of the law in Florida in the absence of an authorizing special act.
Okay, questions or comments regarding ability to cap millage or restrict to CPI? Yes, Commissioner Marie Brooks.
So just for my clarification, that would mean that we would not be able to suggest or recommend like a 2/3 vote on the budget into the, right, that would...
That's exactly right.
Right, that's what I
and
heard,
thank you
and I
very
wanted
much.
to-
Yeah, thank you for bringing up that point, because that was actually kind of the a layered on question that the Attorney General's office addressed in that instance. The question that was posed by Hillsborough County to the Attorney General's office was, can you put a cap on increasing your annual budget, but can you set it up so that you have an escape hatch, with a supermajority vote? And the Attorney General's office said no to either. And the reason it said no to either was with regard to capping it generally was 129 and 200 are the uniform processes by which you do it. And second, the Chapter 200 in particular specifies specifically minimum majorities and supermajorities necessary to pass certain budgets. So it gets into the weeds. And so it made the point that to specify a higher standard when a state statute had already expressly provided a standard would be contrary to general law.
Yeah, of course.
Would we be able to entertain putting in a new role, a county budget officer that would work directly with the commission? My thought on that from conversation would be that this person would be someone who would deal directly with the county commissioners, would answer to them, and would be able to provide them a extra level of understanding and maybe negotiations in what they're voting on for the budget season.
So
I think this year
a
there's-
charter officer
Right.
appointed by the county commission
Yes.
as opposed to staff that's appointed by the county administrator.
Correct.
I've heard this as well as a
Yeah.
concern.
Okay.
Do you see what we're saying, Mr. Rose?
Yeah.
The
I think
concern
so.
being, if you were, for example, if you're elected in November to the county commission, you're already basically getting to the budget process, because the budget process is going to start in the spring, and then you're voting on it in July, and then you're voting on the trim in September. And so if you're a newly elected official, you have probably very little time and probably very little ability to actually impact that budget. And maybe to even understand it, to be completely frank, if someone coming in, brand new. So this is an idea that I've also heard from some folks that are concerned about the county commission having more independence from the county administrator's office on developing the budget, or perhaps having their own advocate, having also understanding that with 7 county commissioners, you may have 7 completely different points of view. And so then that charter officer may also be trying to, navigate that process. I don't know, Commissioner Eggers, do you have thoughts on that, or they didn't want to put you on the spot, but.
Well, if you're going to, clearly you're not changing the idea of having a budget presented by staff. Presumably that's staying in place, or am I hearing something different? Because the staff is obviously the one that implements everything that we, from a policy standpoint, set. So you're going to have somebody develop the budget. The idea of having somebody, a special officer that reports to the commission, might have, it's kind of like well, many times I feel like I go to commission meetings to argue budgets with one hand tied behind my back because I'm not as versed, as many years as I've been doing this, I'm not as versed as the staff is at painting a picture that, is different than my vision. So, but I think that from my perspective, it means getting more knowledgeable and getting closer to the action, if you will. But I don't think, I still can't imagine a process that doesn't have a presentation of a budget from staff. Maybe there's room for somebody to help.
I don't think the idea is to eliminate staff or to stop what they do. It's more of a person that would work directly with the commission in a different way. I'm probably not explaining it very well. But I'd like to come back with some more information on that.
Sure.
It made me think when you explained the things that we can and cannot do. It was just my question, would that be something that we could expand on? So I'd like to come back with some additional information. It was just my thoughts.
Certainly, yeah. No,
Yeah.
I've heard the same concern. I know Commissioner Jennings wants to make a comment. Attorney Vos, do you want to go now or?
No, go ahead.
Okay.
I was just going to say, for your edification, if there's something he's going to be asked to look at, I think there's a House bill and Senate bill. I'm not sure where they stand, but I know there was a House bill and Senate bill presented this session. I think it was the GM Bardo, maybe, in the Cape Coral area. And I think Jonathan Martin was in the Senate.
Is it touching on county budget officer?
On this exact topic, so it might be a good place to look.
That was part of what was tickling in the back of my head, yeah. That there's a, just as the commissioner said, I believe there is a bill running right now that I don't remember what it said. I just remember that it addresses the question of county budget officer. I just wanted to note two thoughts about the exact term, and I want to make sure we're all talking about the same thing. The term county budget officer is a term of art, and I'll point to at least two places. Term of art. It means something very particular, and I'll tell you two things of what it means. One, the county charter currently, the Pinellas charter lists as the 5th duty of the county administrator to act as the county budget officer and carry out the duties of such budget officer as required by law as directed by the Board of County Commissioners. When we reference the term county budget officer there, it's referencing Chapter 129. And Chapter 129, which I had mentioned with regard to the rest of that, in the relevant provision, each Board of County Commissioners may designate a county budget officer to carry out the duties set forth in this chapter. So basically, there are a whole bunch of things that have to get done to make a budget happen in Chapter 129. The county budget officer is the officer that makes it all happen, makes all the trains run on time to do all of that. And under the Pinellas County Charter, it's expressly designated that the county administrator is the county budget officer. So that carries a lot of baggage with it, that exact term. So I didn't know if it was a thought to put that exact set of duties with someone else, or whether it was to specify a discrete set of duties, to assist commissioners or what have you.
Yeah, what I had heard was more the idea of like a liaison.
Gotcha.
But I think it's something that we should look at that legislation, and we should also look at what other counties might be doing, and let's just add it to the list of something for you to come back with, and maybe each commissioner, if you come up with additional information, send it to Doug directly. Don't send it to the rest of us, obviously, but send it to Doug directly, or send it to Wade and Doug, and then they can, maybe aggregate all that, and we can go through it. So, yes, Mr. Thomas.
If I could add, this may be similar in point to what the commissioner was raising. I only know this because I was involved in a recruitment with the city of Fort Lauderdale, so it's a city, not a county, but they had a position there referred to as an internal auditor. And by charter, just as legal counsel Vose has indicated, the city manager in that case presented the budget and all that information came forward by charter. But the auditor had an opportunity to review and determine fiscal sufficiency, and there were other provisions associated. So I think that may be kind of what you're getting at versus that, and maybe that's another angle that might be of interest for exploration, if that's what I think I hear you say.
Chair.
I think
sorry.
Property Appraiser Twitty had
Please,
a comment too.
Sorry, I just wanted to jump on something real quick on that. I'm familiar with the role you're talking about within a municipality. I think Ken Burke's ears would have perked up to hear reference to an internal auditor within a county, because the clerk of the circuit court is the internal auditor is the auditor for the county. So, and in years past, it wouldn't have concerned me so much to say, oh, we'll have one, we'll have two, we'll have seven, what have you. But they actually passed a law this last session previously that expressly, I think, almost made it a crime to pass an ordinance or to amend your charter or anything like that to circumvent or take over any of the powers or responsibilities of any of the 5 constitutional officers. That was all directed to a particular weird thing that was going on down in Miami-Dade County and the sheriff, as I understand, but it was written in broad language so that counties can't get in and fool with any of the constitutional powers, and that's expressly one. So I just wanted to throw that idea out there. It's a very fair point. This probably is a fair point to some of the idea bouncing around, but it's an area where we'd want to tread lightly. I'm so sorry.
Property Appraiser Twitty.
Yeah, no, I wanted you to finish your thought because I knew they were tied together. I just also wanted to bring up there's also legislation pending on the millage caps right now. It would require a 2/3 vote. So that's on the special order calendar in the House for tomorrow, I believe. And it's cleared 2 committees in the Senate so far.
Okay. Commissioner Jennings?
Yeah, I was just going to say for legal counsel, it's House Bill 1553.
And that's for the budget liaison?
I'm just reading an article I found. It just says it specifies a county budget officer reports directly to the Board of County Commissioners.
I see. Okay. All right. Yes, Commissioner Butler.
Just to add to that, I pulled it up here. I'd say that it and the Senate bill are kind of dead on the vine because still tied up in committee and haven't had any votes on it. And
okay.
It's kind of late in the game. So.
Okay. Any other comments on 6B? Okay, good discussion and potentially some new topics to look at. That's great. Item 6C, which is related to the specifically designated county environmental lands protected under Section 2.07 and subsequently purchased and designated environmental lands. Mr. Vose.
Thank you, Chairman. This memo, just wanted to... Wait, please. Sorry, it was off there. This memo just documented what I think I had briefly mentioned to you before, but wanted to clarify because there was a question about it. And the question was, how do we handle newly acquired or newly designated environmental lands under the charter? And I think the question was, do we need to do a even cleanup charter amendment to add any additional reference to additional lands to add it to the list? The answer is legally, there's no requirement because the charter amendment that put in this 2.07 expressly provided for dealing with that. When the Board of County Commissioners designates additional environmental lands, it gets locked in just the same as if it were listed in the charter, and there's no taking it out without a referendum. In any event, though, when I took a look and went looking through Municode at the list of designated environmental lands, it looks like, as far as I could see, none had been added by the Board of County Commissioners since this provision was added to the charter way back when in 2008. So, so there haven't been any, so there would be no even cleanup amendment to make. If I'm incorrect and there has been one added, but somehow it wasn't on Municode or what have you, you could add it to the cleanup amendment if you wanted to, but legally it's not necessary.
The
So this
county
is just a
commission
minor.
can do it on their own.
That's correct.
Right.
Yep.
Okay. Any questions on that? Comments, concerns? Okay, moving on to old business. This is some draft language. Again, as you all know, we're not voting on final language or putting anything on the ballot tonight, but Attorney Vos and Mr. Thomas have done a good job of making sure we have some work product and some information well before our deadline, so we can start thinking about it. The first topic and the first language that they've drafted for us to look at under 7A relates to reducing the percentage required of registered voter signatures for a citizen initiative to be certified to make the ballot from 8% to 5%. Mr. Vos, did you want to introduce it, or is that, do you think, sufficient?
I think that's a sufficient introduction.
All right.
And what I would offer about all of this language is just a couple things. First off, I always appreciate having ballot language ripped up and put it back together. So if you have any concerns or anything like that, please let me know. Second, if we have related matters, and as you know, per the discussion with the supervisor tonight, there might be other matters that end up being related, for example, to initiative petitions and so on. It may make sense if there are other changes you would make as well on that same subject. Might end up being that the current ballot language that's set forth here might not be what it ends up being. You might combine it all together and so on. But in any event, directed to these issues, this is what you have before you.
Commissioner Eggers, do you have a comment?
No, I was thinking back to what you were saying about that. I was talking about 240 days, and you said, well, they don't have to take the whole time. But there's got to be something in there where we have to give some time for the supervisor of elections to at least, not checking substance, but checking the number of words that were used, et cetera, to be done in a timely fashion that allows for up to 240 days for the prop, because it says it starts once that is approved. Currently, that's what we talk about. So that process has to occur. So whoever brings it in, however they're organized or whatever, they bring it in for review, and the supervisor says, give me, whatever time they need, has to leave that, from their perspective, right, at least 240 days. They can't drag it and then...
Once they're approved to start. Yeah, I understand what you're saying.
Yeah, it's a little bit...
Yeah.
So...
There's a nuance there,
yeah,
for sure.
a little nuance. That's all. Thank you. I don't know why I thought that way.
Okay. Any other comments on the draft language for reducing the number of petitions of registered voters from 8% to 5%? Okay. Just kind of doing a shoehorn analysis, I think there's about 621,000 registered voters currently, so 8% would be roughly 50,000. It's like 49,000 and some change, and 5% would be about 31,000 plus. So to give you a practical idea of how that would go. And it doesn't amend the language that requires certain percentage of signatures to be from different congressional districts or at large county commission districts. No more than 40% may reside in one at-large county commission district. No more than 30% may reside in a single member district. So it talks about making sure there's diversity and geography in terms of where these petitions are collected within the county, and that we're not affecting that at all. At least we're not proposing to affect it at all. Okay, any comments, questions, concerns on that? Moving on to 7B, draft ballot language regarding requiring charter referenda to be on the general election ballot only. So this would eliminate the county commission's ability to have special referenda election and require that any referenda, whether it was initiative by citizens or proposed by the county commission. Currently, all of the Charter Review Commission's questions would automatically go to the November ballot, correct? So that's correct. Not changing that, but it would essentially remove the county commission's ability to schedule special elections for referenda, whether those were initiated by the county commission or initiated by citizen petition. Is there questions, comments, concerns on that draft language? Or feedback we'd like to give at the moment?
Real
Yes,
quickly,
Commissioner Eggers.
if we were voting tonight, I can't remember what we said that threshold was from our group. What was the number of the entire group? I think how many of us are there, 13?
13.
So there was a number of the 13. It wasn't just of those present, right? So if there was 7 of us, I just want to make sure, we're not doing that tonight.
Right.
If we were, and we're
It's
all.
an answer I should know off the top of my head.
So the question
I like
essentially is
to
if
triple
someone's
check
absent,
myself.
do they still count against the majority if they're not present? In other words, if they don't vote, is that, or is it a majority of, what's the quorum? Yeah, that's a good question.
Seemed like it
Mr.
was
Chair,
of the entire.
I've got the, oh,
Mr. Thomas, sure.
I've got your rules that you adopted, if
Yeah.
that would be
There you
helpful. I
go.
think that's what you're asking for,
Yeah.
Commissioner. It says, CRC vote requirements unless otherwise provided by Robert's Rules of Order, newly revised. These rules require a majority vote of those members present shall be sufficient to move an issue forward at the time the issue is discussed, excuse me. An issue that is initially voted down at a CRC meeting will be reconsidered following Robert's Rules of Consideration. And then an affirmative vote of the majority, the full membership, affirmative vote of 7 members shall be required for final approval of the final report. I think that's what you're getting at.
So just of those present, just to move the discussion along, but at the end, to choose to actually be on the ballot.
Yeah,
it must
absolute
be
majority,
7.
which would be 7,
votes.
yes.
Okay. Okay. And I think what we've talked about is not, we're going to do that all at one meeting, probably when we adopt the, we give you the final direction on the report. So hopefully that's something where everybody knows about it and we can make sure that as many people, hopefully everyone can be here. So that we'll definitely make sure that's very well known when we're actually taking final action on these recommendations or these items.
And Chairman,
Yes.
just as an additional procedural bit to that, and we'll get to talking about that eventually, there are public hearing requirements after you have firmed up what the CRC plans to put on the ballot. Basically, is going to get to the point where you firm up, all right, you have an absolute majority, you have at least 7 in favor of putting this set of amendments on the ballot. Then once you have that locked, you're going to have a couple public hearings that are going to be spaced out the particular way. After the holding of those public hearings, then you can take your final vote to say, yep, after hearing all the stuff, we're still going to put them on the ballot.
Okay. Any questions on the process? All right. Moving on to 7C. This is the language regarding conforming with the Florida Election Code, specifically related to notice, which I believe County Attorney White had referenced before, and simply removes some additional notice requirements that the county charter has in favor of the statute that governs this under Florida law, which requires, I believe, it's 4 weeks. Okay, instead of 5. So any questions on that? Comments, direction?
I'll just mention with regard to the ballot language on this, I've endeavored, and I've read other ballot summaries in the past that get really into the weeds of, oh, it's this, and it's this, and it's this, and it's this. That's not particularly relevant to the chief purpose, which is what the law looks to for a ballot summary. What the chief purpose and main legal effect is to do precisely what it says here. It conforms it to the Florida Election Code, doesn't have something that's slightly out of conformance with it, so you're having to do even more. So that's thus the kind of simplified language you have here.
Okay. Any comments before we move on? Okay, 7D is the 2 options. So you've got A and B, and this relates to the hiring and termination of the county attorney. Option A would require a supermajority to hire the county attorney, 9 out of 12, and then a 9 out of 12 to terminate the county attorney at 1 hearing, or a 7 out of 12 majority at 2 hearings. And then option B would essentially just lower that 9 to 8. So you would need 8 to hire, and then 8 to terminate at 1 hearing, and then 7 to terminate at 2 hearings. Comments, questions? I don't know if the county attorney would like to weigh in on this.
I just wanted to add an additional wrinkle to the second option.
Yes, sir.
So if you recall, the prior draft I had provided to the commission was 8-vote supermajority to hire, 8-vote supermajority to fire at a single meeting, or 7-vote majority to fire at 2 consecutive meetings. Option B here had a different elaboration that I believe the commissioner had suggested. And so the 2 options are a higher supermajority vote on option A. Option B is that lower supermajority threshold, but that the appointment or removal has to be approved by both a majority of the county commissioners and a majority of the other constitutional officers on the committee. Might be a little too complicated, it might not, but it was what I was hearing going back and listening to everything from the meeting as different options discussed. So that's what that other option is in option B there.
So for termination, if it was 7 county commissioners and 0 constitutional officers, then the termination would not be effective, even if it was held at 2 consecutive meetings?
That's correct.
Yeah, I don't think I like that. That's just too complicated. Yeah, I think it's too complicated. I mean, I would love, I don't want to put the county attorney on the spot. I think that it becomes very difficult for an attorney, and I know that municipal attorneys and county attorneys are different because they have, you know, a wide array of municipal and county clients and different departments and agencies and, you know, sometimes different hats that they're wearing depending on what the issue is. But if you have a majority of your bosses say they want to fire you as an attorney, I almost feel like you have an ethical conflict of how do you continue, even if the law says you're not fired. If a majority of your bosses say, or a majority of your clients say they don't want you to be their attorney anymore, it becomes very difficult as an attorney to effectively represent those clients. And it almost becomes like something I would wonder what the Florida bar guidance would be on that, like whether you can effectively represent a client, even if legally under the charter you're allowed to, if a majority of the client says they don't want you to. So I understand that we certainly don't want to have a position where we have the county commission having an outsized voice over the constitutionals in like kind of an unfair setting on a one meeting basis. But if we're talking about 2 meetings in a row, I would think a simple majority would be sufficient. And I'm specifically thinking about the hiring too, because we're blessed here that we have, you know, great in-house candidates, and our county attorney's office is very robust with a great group of county attorneys. There's a whole bunch of county attorneys. A lot of towns and cities don't have a whole lot of in-house attorneys, and so usually those searches are consultant driven. And so you might have a situation in the future where you have 2 or 3 really good candidates, and it might come down to, you know, kind of subjective opinions of the decision makers. And so if you're going to require 9 votes to hire somebody out of 12, I mean, that, I'm just thinking down the road, you know, years and years from now, I don't want to hamstring the committee by saying you can't hire somebody unless you have 9 out of 12 votes. I mean, that seems like a really high burden to put on these folks. I know we're not making this decision tonight, but it was the one area where I know we're trying to fix a problem of not being specific enough, but I don't want to be so specific that we create problems for future decision makers like 20 years from now that are wondering why did we make this in the first place, you know? Yeah, Commissioner Eggers, please.
Yeah, it's a good point. I mean, and the flip side is we're trying to make sure that the constitutionals have a voice. And so, you know, like I said, with 7 commissioners, they could make a choice, and constitutionals don't have a voice. And the reason I keep going back to 9 is I think it's a threshold that's important to meet when you're hiring somebody of that ilk. And that really makes, I don't know what a supermajority is by definition. I know that we always look at it on the county commission as 5 out of 7. So I'm thinking 4 out of 5 constitutionals, which gives you that high threshold of 9 people. Now, to your point, if you have 2 candidates, you know, you're picking one over the other. At the end of the day, you still have to have a vote to hire that person. And I think that's where you get into that. I think it's really important that on the county commission, the county attorney have a high threshold. And I want to give the constitutionals the same voice that we have. And I'm, you know, personally, I'm flexible on the 8 or 7 on the removal part, because to your point, if 7 of the 12 don't want you, I think it's time to say goodbye anyway. But anyway, those are just thoughts.
Yes, Commissioner Steck.
I remember from before, one of the issues had been that the constitutional officers had no real say in the hiring of the attorney that represented them. And I know what you're saying as far as having a majority of the constitutionals vote as well as the other. It's a little Byzantine, but on the other hand, at least they'll have representation as in choosing their attorney. So that.
And that's clearly what the voters said last time. They wanted the constitutionals to have a say, a strong say.
Vice Chair Grove.
I was just going to say, I mean, I also imagine too that the hiring process to become a county attorney would be really stringent, and you know, that I think certainly is a consideration when, voting on something like that, they're bringing forward the very best candidates. So I do agree that having a high threshold, in my mind, I guess realistically, it should already be there, because by that point, by the time those candidates are being brought forward and being recommended, they would have already been the very best candidates and likely been a good fit, I guess.
So do we want to give any more specific guidance at this point, or do we just want to keep these two options out there for future discussion, or? Yes, Mr. Pochich.
So by the sounds of things, it might make sense to eliminate the first one and just kind of tweak the second one. That way it might streamline our decision-making down the road.
I'd personally be fine with that. So, I mean, it sounds like what you're saying is go with the 8 for the hiring and 8 for the firing at the first meeting, but remove the requirement that the 7-vote firing at 2 hearings has to be a majority of the county commission and a majority of the constitutional officers combined?
Not exactly. My recommendation was that we just tweak option B and eliminate option A, because it sounds like
Option B has the caveat that you have to have a majority of the 7. You have to have 4 county commissioners and 3 constitutional officers, which would be 3 of 5 and 4 of 7. Which I think those who have spoken so far have said maybe a little too specific, maybe too.
Yeah, I'm just trying to get down to maybe zeroing in on one option moving forward.
I personally think the 8 majority instead of the 9 for firing at 1 hearing or hiring is my preference, and then 7 at 2 hearings for either hiring or firing. Because if you got a situation where you couldn't get to 8 for hiring, why should we not have a county attorney or have an acting county attorney? I'm just trying to think practically down the road of what could potentially happen and avoid that. Commissioner Steck?
My thought is, I'm wondering if the removal procedure shouldn't require a higher vote, because I've just run across situations, you hear about them, where a county attorney gets into, not here necessarily, but does something to offend some people, and a certain group get really riled up about getting rid of them. And if the person's doing a good job and an effective job, we might make them subject to whims of people at a certain point in time. See what I'm saying?
So instead of the 8 out of 12 for 1 firing, you'd want 9 out of 12?
For firing, I would say, yeah, a significant majority, so that it's obvious that this person, as you were saying, is just screwing things up. You need to get rid of them, as opposed to being possibly impacted by some issue that might have a lot of emotion attached to it, and therefore cause a person to be removed that just happened to do something that didn't appeal to a number of different folks. Whether that's
Commissioner Brooks.
So I understand what he's saying. Given the media and different instances that we've had across the state of Florida, I would probably lean towards less to hire and more to fire.
Okay.
Because of that very reason.
Yes, Commissioner Strickland.
8 out of 12 is 2/3.
Yeah.
I'm okay with that.
I am as well. I'm almost thinking, I don't want to go into specifics, but there could theoretically be conflicts between the constitutional officers could be suing the county commission, or one of the constitutional officers could be suing the county commission. And maybe the county commission is upset how the county attorney's involved with that, and now you're going to give 3 constitutional officers or 3 county commissioners a veto over 9 other county commissioners and 9 other constitutional officers combined. I don't know. It could get very dicey when you make a veto power so limited to only 3 or 4 people out of 12. That's a lot of power, and it's certainly again, as an attorney, I would feel very conflicted in a situation like that where you might have the person just resign anyway. But it sounds like we probably need to have some more thought and more discussion on this. I don't think we're going to make a decision. I don't want to rush a decision. And it's a good topic. It's something to definitely consider, because it's it's like one of those rabbit holes. You could go down and come up with 20 different scenarios and have good arguments on both sides of why. Any other thoughts or guidance on that or comments? Okay. Moving on to 7E, we're getting an update on the term limit legislation. Attorney Vos, I don't think you need to go. Oh, yes. Oh, that was Mr. Thomas?
Oh, yeah, I was gonna throw it over to Doug.
Okay,
'cause
I don't
Doug
think
put
we need to
together-
go into extreme detail on all of these bills. You can just let us know, is anything moving? If so, what are the term limits? If not,
Certainly.
it's not moving.
We've been just tracking this. Obviously, this is a topic we have not dealt with yet as a board, but we wanted you to be aware that the state legislature is working through it. As you followed the progress of these two bills, what has happened now is there's symmetry between the two of them, which tends to indicate there's some consensus going on up at the Hill with regards to where they may be going. They're not set for final review yet by either the chambers. They're just still working their way through second readings on the committees. But just if you have not had a chance to go through it, what basically says is that if you do not have term limits in your existing charters at the county level, and the term limits specifically are identified as notwithstanding the terms, a person may not appear on a ballot for any re-election to the office of the county commissioner if by the end of his or her current term of office, the person will have served or for resignation would have served in that office for 8 consecutive years. The person may not qualify or appear on a ballot for a different district seat of the county commission or an at-large county commission seat of the county after his or her initial 8-year term of office until 2 years thereafter. What they're proposing under both these bills is that at the upcoming general election, the November general election, that language to that effect would be placed before the voters. If in fact it is approved, the state statute would go forward. If it is in fact rejected, then the state statute would not kick into effect. So we don't know where this is all going to shake out at this stage, but it is still progressing through both the House and the Senate, and at some point where it'll be another topic of conversation here. So we wanted you to just be aware of that process.
Yes, Mr. Twitty.
I was just going to add that it was in rules today, but I haven't seen the verdict yet.
Okay. Commissioner Eggers?
And there seemed to be some discussion, like you were talking about, would they be dictating to the counties to put it on their own referendum, or would it be, I mean, how would that work?
Wade and I briefly discussed that before tonight about the language and how that would trigger. So once again, I will not venture into being an attorney. I'll defer that to Wade.
The latest draft appears to provide that each county that doesn't have at least 8-year term limits in their charter, which would be most counties in the state, because most counties are non-charter counties, that there would be a referendum separately put on each county ballot in November. And it specifies the ballot language of what the question would be, and if in a given county, including non-charter counties, that referendum passes, then the term limits go to effect in that county. If in the next county over it doesn't pass, in that other county, they don't go into effect. So this has been, I'll just share with you, because I've had some insight dealing with the folks up at the Florida Association of Counties. This has been, I think, kind of a fallback measure. Florida Association of Counties has been looking at with this. They don't want this to pass, as you can imagine, particularly the folks in the non-charter counties where they don't have to even think about any of this. But the fallback position had been, well, if you're going to do this, at the very least, make it a county-by-county referendum so that if anybody's going to do it, it's my own voters doing it. That's what I got from one of my county commissioners in the county where I'm county attorney.
And they took away the argument that the state's going to force it on you. They're going to force a referendum on you, but they're not going to do it. They're not going to unilaterally decide.
Politically, they took away that argument, yeah.
Okay. So, yes, Commissioner Steck, please.
I'm apparently dense on this, but I noticed the law kept on referring to a date in 2004 or 2024, and the examples referred to something in 2022. What is the?
Yeah, and again, I haven't been keeping track. This is kind of wobbled a little bit in the different bill versions, but at least some of the bill versions that had come through, they were slightly retrospective. And what I mean by that is they would start counting terms from when folks were elected in 2022, as opposed to being purely prospective, where it would be from that election that it was approved on onwards, which is not legally mandated, but more typical of what you see of term limits.
Okay, but so that is the law that's being proposed. I mean,
I think the version bouncing around right now is saying terms. Yeah, I'm actually the latest version of the bill. I'm not sure whether it's start counting at 22 or start counting at 24. Again, it's oscillated in the various drafts, so I'm not perfectly sure where it sits right this second.
Mr. Thomas, are you? Is that something that you were clear on?
I'm similar to what Wade's saying on this one. This one's bounced around a little bit before. What it looks to be, if you take either one of the bills, just give a second here to review it to make sure it's prospective. It says by the end of his or her current term of office, the person will have served. So it looks like if you're in office now and if you have served 8 years or more, at that point you would be triggered by this provision that would potentially limit your exposure, having to sit out 2 years, once again, assuming election took place in your respective county and that election approved the language as proposed by the state statute.
Thank you. Thank you both.
Commissioner Jennings, did you have a comment?
I just clarification, because you talked about the referendum elections. Is that for all the counties or just counties that already have term limits that are in excess of the 2 terms?
No, it's for all counties all counties that don't have term limits or have term limits of, say, 12 years.
So should I ask the terrible question? What if we put a 12-year, 3-term, 4-year term, 3-term, 12-year on the ballot?
Mm-hmm.
And because we didn't have it in place, this was also on the ballot for 8, and they both passed at the same time.
Sure. So both could pass, and they're not legally inconsistent in this sense. A 3-term limit would go into the charter, and a 2-term limit would be imposed by state law. So there they would both be, but no one's going to get to their 3rd term because state law is going to kick them out.
It's going to supersede.
Yeah.
So because we don't have it, if this legislation goes into place and the 8 years passes, it doesn't. If we don't recommend 8, if we recommend 12 or whatever, it's going to be irrelevant. So, Mr. Treaty, no. Okay. Any other comments, questions on this topic?
They did say something about if you're going to run for another seat, you had to wait at least 2 years, right?
That's the Hillsborough, yeah, because I think in Hillsborough you can go from single district to countywide and serve 16 years, and they're saying you can't do that.
You have to sit out at least 2.
You have to sit
Obviously,
out.
for your own seat, you have to sit out at least 4.
Mm-hmm.
But for that other seat, that the partnering seat, because we're all eligible for 2 seats, the other seat you'd have to sit out at least 2.
Mm-hmm. Okay. Anything else for the good of the order before we talk about the next meeting schedule? Okay, so the next meeting is scheduled for Wednesday, March the 6th, followed by Wednesday, March 20th. Session's not over until March 9th. I think we've been kind of waiting to put the term limits on the agenda till we see what's going on with this. And specifically now that this is kind of where we're at, not that that's where we're going to end up. It does seem like it might be a colossal waste of our time and the citizens' time to discuss a term limit referenda on March 6th when we might have something very different from the legislature. So I think maybe let's just get an update on the legislation on March 6th. Is that okay? And we'll have additional meetings, plenty of additional meetings to talk about term limits if it's something that we do want to take up in earnest. Is everybody okay with the March 6th date as of now? Yes, Commissioner Butler.
I'll just be late, probably.
Okay, that's fine. Is there anything on, I think, Mr. Vos and Mr. Thomas have a tremendous amount of topics that we've given them to look at, and so I've no doubt we won't have a problem making an agenda. Is there anything specifically, Mr. Vos or Mr. Thomas, that you want direction on for the March 6th agenda, or anything that the commissioners want to see on that agenda that we can give you some additional discussion on?
Wade and I can certainly get together to talk through what's left. There's only a couple topics left that we have not really ventured. Obviously, term limits being one, the county executive being one. We could probably run down a little bit of the research on the new topic of this extra charter officer, or whatever that looks like. We can probably pull something together pretty quickly, at least to get a sense of how that might work in some other areas. I'm familiar from the city standpoint. Wade may have some ideas from the county standpoint, but we could probably include that as a topic as well.
And I know, it's not that far away, obviously.
Yes.
So I don't want to load y'all up, but obviously we have the supervisor of elections process for the certification of the initiatives and when that's supposed to start. So I know that may not be a next week thing, but maybe by the March 20th meeting, we might have something on that.
I would, that would be the plan. Yes, and the March 6th meeting is probably not going to be as loaded as this one, but give you an opportunity nevertheless to discuss various matters.
Mr. Chair, I think Wade and I both found out we've got some potential conflicts on a couple of these dates. So I don't know, Wade, if you want to jump in as well. I think you said you've got a problem on the 20th, and I know I've got a problem on the 3rd as well, but I wanted to talk through those.
Chairman, unfortunately, I have a fair bit of uncertainty that's arisen. It is possible that there's a meeting that I absolutely cannot miss in another part of the state on March 20th that has popped up, but I have tried to get certainty on it, do not have that yet. I'm hoping to have it by next week, but I'm not sure.
So if we were to cancel the March 20th meeting, we would be deferring to the April 3rd, which isn't too far.
And that's
away.
the one I now have. I have a similar
You can't do
situation.
April
I can't
3rd.
do the 3rd anymore. That's the challenge I've got.
All right, it sounds like
the 13th of March could work, which I don't want to.
Why don't we do this? Why don't you guys send out an email tomorrow
That's what I was
on
getting at.
scheduling? Because I don't think scheduling in person is ever works out real well. So let's send it on email tomorrow and see if we can. It sounds like we're going to keep March 6th. Okay. Unless you all think that moving to March 13th makes more sense from a workflow perspective and you'd be more prepared with more topics and it works for the vast majority of everybody else. So I'll leave it to your discretion, your professional discretion in how you want to recommend going forward with that. But why don't you send out an email tomorrow? It sounds like you have conflicts with March 20th, Mr. Vose, and you have a conflict with April 3rd, Mr. Thomas. And we'll resolve those conflicts via email. Is everybody okay with that? Okay. All right. Anything else? Yes, Mr. Steck, Commissioner Steck.
I hesitate to make a proposal, but this is something I've thought over for years and years, and I've talked to a couple people who said, you really don't want to bring this up, but I'll go ahead and do it anyway. We have 24 cities in this county, and it's dawned on me that there are costs related to maintaining a city hall, or having the commissioners or council people receive salaries, admittedly small salaries, but what I'm getting at is there seem to be costs associated with maintaining a separate city that if those areas were simply part of the county, as in Jacksonville or some of the other places, that there might be a cost savings to the citizens in those areas. And I wondered if it wouldn't be worth discussing whether having someone jointly in the county and within each of the municipalities put together a budget comparison showing this is what it costs to maintain the city as a viable entity versus being part of the county. And I don't know if that's something that the rest of the commission has any interest in, or.
I think that, Mr. Vose, you might be able to give us the broad outlines of how you would consolidate cities into a county, but my guess is it's going to be dual referenda and potentially a special act?
It's
pretty complicated, but go ahead.
To actually accomplish that, that's its own thing under the Florida Constitution called consolidation, actual consolidation of the whole governments, and that would take a special act to accomplish that.
So the legislature would have to approve it.
Yeah.
My point here is not saying anything about that aspect of it, but just simply presenting numbers to the citizens each year. And if they're happy with spending whatever difference there is to maintain a city, fine, but at least they'd have knowledge about what the costs are at doing that. So I'm not saying anything whether they should become part of the county and collapse the city or have the city, maybe even have more cities, I don't know. But I'm just saying I think just the knowledge being provided to the citizens so they know what they're doing and what it's costing them one way or the other may cost them more to be part of the county, who knows?
Who's going to do that study?
I'm sorry?
Who's going to do that study?
I have no idea. I'm just saying it would maybe have some part of the county as an addition, having a member of the city for that particular city, because otherwise it would appear to the citizens that the county's trying to ramrod something through about getting rid of the city, and that's not at all what I'm after. It's just presenting some more information to them.
Sounds like data information.
Exactly.
Okay, I understand. Any other topics or comments that we'd like to talk about before we adjourn? All right, we stand adjourned. Please check your email for scheduling information. Have a great week. Thank you.